now joined by one of the most sought-after criminal lawyers in the country, someone who's known in a career spanning over 3 decades, senior advocate Mr. Amit Desai, joining us on a story in which we are the only channel carrying the story about the 104-year-old Lakhan, whose life was stolen by the very system meant to protect him. Mr. Desai, thank you for being with us. And first question, he says this is justice done after 5 decades. Is this justice or injustice, sir?
Well, considering that he has been given the benefit of doubt, it's clearly injustice. And, this issue, we've been talking about the criminal justice system being in shambles for quite some time now, and particularly in relation to releasing inmates who are now elderly is a matter which the Supreme Court has been dealing with for the last nearly over 10 years. I must tell you that about 3 decades ago, in a celebrated judgment of the Supreme Court of 7 judges in Ramchandra Rao's case, the Supreme Court settled the law that Article 21 rights extend from investigation all the way through to appeal. Now, an Article 21 right is really of 2 types. One is the right to speedy trial, and one is the element of life and liberty. So when you deal with a situation like the one that you have brought to the notice of the viewers today, I think it shocks the conscience of anybody that a man who went into jail in 1977 comes out in 2025 acquitted of the offense, and it's quite shocking. And I don't know whether we have anything to say to him and his family. I think there's tremendous need to bring about significant changes in the legislation to deal with these kind of matters. I must tell you that the Supreme Court has been very concerned with this problem. In fact, as recently, apart from a PI that was filed in 2015, where the Supreme Court directed that all prisoners above the age of 70 should be immediately released on bail, and for a long period of time that was not undertaken. Recently, in late 24, NALSA has filed a petition again in the Supreme Court under the guidance of the current Chief Justice, as he's now Justice Gawai, for a direction that aged and ailing prisoners must be released from jail as a matter of human rights considerations. I must tell you that in 2023, I was invited by the Select Committee of the Parliament to give suggestions in relation to the new laws. And I too had made a recommendation at that time that it's time for the legislation to actually provide for bail to the elderly and even during the period of appeal. I personally believe that the only way this problem can be solved is by ensuring that bail is granted instantly when appeals are pending for more than 10 years or 15 years. You may put any cutoff, but bail must be granted instantly when appeals are pending. I think that's the only way you can solve this problem, and it must be done through legislation. You can't leave everything to the courts to do.
Mr. Desai, you come from a family of lawyers. You've been working with the legends of law, whether it's Nani Palkiwala, whether it's Fali Nariman. Yourself, you're now one of the topmost criminal lawyers in the country. You've often spoken about the problem of pendency that needs to be sorted. But when it comes to also justice that needs to be given, how can we change the system? This is just one of the many cases as a statistic.
I'm fairly clear about this, having seen this for a long period of time, that whilst it's clear that we need to protect victims' rights when a crime is committed, it's equally important to protect accused rights, because they can be proved to be innocent, as has been happening in many cases. We've seen this one. We saw a few months ago, even in the Supreme Court, so many convictions have been overturned after decades. And therefore, there is a need for a balance between the victim's rights and the rights of an accused. And I firmly believe that this must be done through legislation, because at the end of the day, the district courts who are seized with these problems, the jailers who are seized with these problems, the prison authorities who are seized with these problems will actually first look at the legislation and implement the legislation. And they don't have the time to read all the judgments of the Supreme Court to decide what's to be done and what's not to be done. And therefore, I personally believe that unless we bring about an amendment to the legislation and deal with this problem at that level, we're going to continuously face this issue. In fact, just to tell you that when you go back in time, when a lot of accused were under trials, were languishing in jail, under the Criminal Procedure Code of 1973, there was an amendment that was brought in where it provided that if an inmate has spent more than half his sentence waiting for his trial, he is entitled to bail. The new law also has a similar provision. However, we don't have a provision when appeals are pending. So I think it's a matter where the legislation must take this up quickly and actually provide for it in the legislation. We've had so many PILs in the Supreme Court advocating this proposition, protecting human rights, but I don't think it has actually had any significant effect in the system.
Yes, sir. Sir, I thank you for joining us. This was a very interesting thing that you've actually told us about how this can move forward. Lakhan's journey is going to be India's wake-up call because the snail's pace justice will just not do. I thank you, Mr. Amit Desai, for being with us on Republic TV with this eminently very experienced perspective that you bring to us. Thank you, sir.